Hello friends, welcome. In this video I'm going to talk about the separation of power. Now before we delve into this discussion with a polity context, I would like to ask a few simple questions. What do you understand by the expression separation of power? I'm sure most of you will say something like division of power or compartmentalization of power, breaking down of power into smaller units, power को बांट देना. That is what it basically means. Now and then I would have a follow-up question to this, which is why do you think separation of power is needed in any sphere, not just in terms of polity again, in any sphere? So the answer that I would like to hear is that separation of power is essential because concentration of power is not desirable. Concentration of power may lead to arbitrariness or it may lead to instability. Anything like if say an object is heated to an extent where it's glowing, now it starts shooting radiation off. Now, for example, our sun is constantly ejecting not just radiation, particles as well, because it's so hot, so much energy is concentrated that it is ejecting energy constantly. And we do not want that to happen. We want things to be stable. So, similarly, you can draw the same analogy to polity as well. Now, in polity, you know that a state, the term state, sorry, I'll change the color so that it's more visible. So, state is divided into three organs. One is the executive, other is legislature, and the third is judiciary, as I've written here. Now, if you listen to news regularly, you can draw parallels with government, that is the ministers, PM and other ministers. Then we have legislature or the parliament, and then we have the Supreme Court, High Court, and other courts. So now you know that the government, it runs the administration. So you would hear that सरकार ने आज इतने offices का तबादला कर दिया, or that government has transferred so and so officers from this district to the other district. So thus it concerns with the administration. The parliament makes law. So the like laws like Citizenship Amendment Act or National Food Security Act, Aadhaar Act, all these acts are made by the parliament. And then we have the courts which deals with the dispute. आपका कोई property dispute होता है, आप court जाते हो. So say you have any like you want divorce, you go to court. You want, let's say you even when you are going against the government, so you have some grievance with the government, so you can go to court to challenge the state. So this is how the organs of state have been divided. So the first one, the government or the executive, second one, the legislature or the parliament, congress, depending on the place where you are, and the third is the judiciary. So now like here we have written, let me write it here. So deals with administration, this deals with lawmaking and deals with adjudicating the disputes. So these are the functions of these three organs. And this division of function between these three organs, this is separation of power itself. So the power of the state that was basically to run the administration, to make laws, to adjudicate dispute has been now divided into three organs. Executive, which deals with administration, legislature that deals with lawmaking, and judiciary which adjudicates disputes. So this division of power between these three organs is the separation of power. Hence, if you want to frame it in one simple line, it would mean separation of power is the division of power between the three organs of the state, that is the executive, the legislature, and the judiciary. Now, like I asked the question before, after the meaning of the term, why do we need this separation? So for this, let's go back to the times when the institution of kings were there. So as you know, king was the supreme authority. What do I mean by supreme authority? So now there were officers under the king, but the final say for any decision would have vested with king because no one was equal to him. He was at the absolute head of decision making. Similarly with lawmaking, the king was absolute pinnacle. And with respect to judiciary as well, the king adjudicated on disputes despite they had some judicial officers as well. But the final say would have been with the king. So you would have heard stories also, especially Akbar Birbal, where Akbar used to adjudicate so many disputes. These stories are based on some facts. The story may by themselves be somewhat fictional, but the idea was always the fact. And thus, the king had supreme authority. Now, what history has taught us that more often than not, these kings they were not just, they were despots, and the rule was despotic. In most cases, the rule was arbitrary. There was abuse of power. The kings were more self involved or corrupt, and thus we need this separation of power. So, this is the reason. Now, if you have the powers of executive, the powers of legislative, and the powers of judiciary vested into separate organs, then this despotic, arbitrary, or abuse of power rule will be somewhat curbed. And this is the need for separation of power. So now if you want to complete the meaning of separation of power, you can use it like this. Separation of power is the division of power between the three organs of state, that is the executive, the legislature, and the judiciary, to ensure that power is not concentrated in one hand, which allows that there is no arbitrary or abuse of power happening. So this is the separation of power. Now the separation of power in modern context was given by a French scholar by the name of Montesquieu. I would like you to check the spelling anyway. So he gave a watertight model. Now in watertight model, what is watertight? Waterproof, watertight, that water cannot flow. And if water cannot flow, basically almost nothing can flow. Well, that was the idea back in 1700s. So anyway, let's not go into the intricacies of science. The watertight model here meant that the executive cannot enter the domain of legislature at all. The legislature cannot enter the domain of judiciary at all, and vice versa. Here also vice versa, and then same thing here. So this cannot happen. So this is watertight model. Now this model is not followed almost anywhere in the world. United States has one of the most strict form of separation of power. Even they don't follow this watertight model. So there, the executive, that is the president, has some legislative power. The legislature has some control over the executive, and likewise judiciary has some control over legislature, some control over executive, executive has control over judiciary, and so on and so forth. So the watertight separation of power is not absorbed. Rather, we have developed a concept of checks and balances. I will discuss checks and balances in detail, don't worry. Now before that, let's discuss some of the significance of separation of power. It ensures rule of law. I will discuss rule of law in detail when we discuss Article 14, but for now just know that law is supreme. So no one is above the law, everyone is equal in eye of law. So unlike in the days of kings where the kings were supreme, now the law is supreme. So separation of power ensures this because Say you do not have separation of power, even if there is a rule of law, how would you enforce it? Its enforcement is not guaranteed, and if its enforcement is not guaranteed, that means there is chance of some arbitrary nature, arbitrary action, and rule of law may not exist. So separation of power is essential. Again, I'll explain. Say there is rule of law, but there is no separation of power. So the body which has enacted the law is the same body which is executing the law. Now, this law which is being enacted and executed can be arbitrary in nature because there is no authority to check on the reasonableness or the fairness, the justness of the law or its execution. For example, say you own a restaurant. Now you have been given this power to frame rules for the restaurants, all the restaurants in your area, say their hygiene standard. Now you will frame a law, you will frame a rule which in which your restaurant ticks all the criteria. So if a restaurant is doing better than you, they will not get any perks for it, and the restaurant which is doing worse than you, they will be penalized for it. So what you are doing is you are ensuring that your restaurant gets no, like, is not penalized. So your rule that you have set for restaurants will not be just, will not be fair. So that is why separation of power is needed for rule of law. Either you run a restaurant or you make rule for a restaurant, but you do not do both. Similarly, it is essential for the democracy to function because if in democracy power is supposed to vest with the people, if someone takes absolute power, and then they can just refrain from conducting election, or election can be rigged, anything like that. So separation of power again is essential here. Now there's another concept called principles of natural justice. Now here also separation of power is somewhat essential for it. Like, for example, principle of natural justice, one of its provisions says that you should not be the judge in your own case. So imagine if the legislature and the function of judiciary is done by one organ. Now the laws that will be passed by that organ, when it comes for dispute, that is like if some dispute arising from the law, or if the law itself is challenged that this law is biased, this law is not fair, will the legislature which has made the law decide against its law? No. So principle of natural justice is also, like, separation of power also ensures that principle of natural justice is upheld. Now for details on principle of natural justice, I would recommend you please watch a video on my channel. I have explained it in great detail and it is very insightful, so you can go through it. So thus we see that separation of power is quintessential for rule of law, for democracy. The powers of Supreme Court for judicial review and etc., we'll discuss this soon, is also flowing from the idea of separation of power, because if separation of power is not there, the judiciary will not be able to review what is done by the executive. Or say separation of power is not there and judiciary and executive and legislature are same, why would judiciary even review the action of executive and the legislature? There's no point in doing that. So thus we see that separation of power is essential. And concept wise also it is one of the most essential part. If you understand separation of power, it will be easy for you to understand rule of law, judicial review, functioning of democracy, functioning of principles of natural justice, and etc. So now we have discussed the separation of power in United States system. Now we'll discuss it in Indian system. Now India, unlike US, follows a parliamentary form of governance. In parliamentary function, the executive is part of legislature. So this shaded region is the like the overlap that I am showing. How it is so? Election happens in Lok Sabha, whichever party gets the majority, they form the government, and then council of ministers are appointed. These council of ministers are part of the parliament, and hence the executive is part of the legislature itself. Now the functions may be divided, but they still are part of the legislature, and hence we can say that in India the separation of power is not as strict as in the US. It is definitely not watertight. It is not even as strict as in US. So India follows a very dilute form of separation of power. Here we have the judiciary is independent from executive and legislative, but the executive and legislative are somewhat overlapping, and hence the separation of power between them is a little lackluster. So we follow a loose version of separation of power. Now let's examine some of the provisions in our constitution dealing with separation of power. So the first one is Article 50, talks about that the state will make effort to separate executive from judiciary. That means that the state will take effort to separate the function of executive and the function of judiciary. Now earlier during the British time there was a post of magistrate. The same person was also exercising power as judicial magistrate, and the same person was also exercising power of executive magistrate, and hence separation of power with this respect was not there. So Article 50 stated that state will make effort for separation of executive and judiciary, and it was done. Now we have two separate posts. So there's a separate post for judicial magistrate and a separate post for executive magistrate. Then we have Article 121, which says that the conduct of the judges will not be discussed in parliament. This is to say, ensure that the judges function independently. Now, it can be discussed only when a motion of their removal is being taken. Otherwise, conduct of judges cannot be discussed. So that is one, to separate executive and judiciary. Then another we have, to separate legislature and judiciary. Then Article 122 similarly says that the proceedings of House will not be inquired in a court. So again separating the judiciary and the executive so that they both can function independent of each other. So this is with respect to separation of power in India. Now we come to this corollary to separation of power, that is the doctrine of checks and balances. Now the doctrine of checks and balances, what it does is, what it says is, each of the organ exercises some control, some check over the other organ. So executive has some check over the legislature, and legislature has some check over the executive, similarly here and here. This is to ensure that either of the organs do not encroach upon sphere of other. Thus, that the separation of power is maintained. So checks and balances is needed to ensure that the separation of power is maintained. It is needed to ensure that if, say, executive is doing something which is abuse of its power, or legislature is doing something which is abuse of its power, or judiciary is doing something which is abuse of its power, there can be a reformative action against it. Now how it is done, so I'll explain. So first let's look at US, then we'll separately look at the Indian system. So executive, that is the president, can veto a law passed by the Congress. Thus, if the president feels that the law is not in good faith, the president can veto it. Similarly, the legislature, that is the Congress, believes that the president is not functioning as the president should, the president can be impeached. So thus, there's a check on both these issues. So if either of these is violated, some action can be taken. Similarly, judiciary through the power of judicial review can check upon the action of executive and the legislature equally. Now the executive appoints the judges, and the legislature can remove the judges, thus exercising control over the judiciary as well. And this is how the doctrine of checks and balances ensure that there is no encroachment or abuse of power. Now let's come to the Indian system of checks and balances. So again, like I have told, the executive in India is part of the legislature itself. So if the executive will only remain in power as long as it enjoys majority in the house. However, as long as it enjoys majority in the house, the legislative action will be determined by the executive, because most of the actions of parliament are through simple majority, and if executive is enjoying the majority, then legislative actions will be controlled by the executive. So that's one. Then the second check is executive can use veto power like in US. So the president can veto a bill of the legislature, and thus this is the control the executive has on the legislature. Now you see, this control, especially with respect to the majority, is quite a substantial one, especially in a government which has majority like the present government has. The legislature is bound by the government because all the bills in the Lok Sabha are easily passed. There's no opposition to it because of the huge majority. And this is why we say separation of power is a little diluted in India. Now, howsoever, let's move forward. The legislature exercises control over the executive through the system of collective responsibility. This is one of them under Article 75. So, what it says that if a no confidence motion is passed against a minister, all the ministers resign, and thus that is the Council of Ministers are responsible to the Lok Sabha collectively. So if Lok Sabha passes a no confidence motion, the executive resigns. So the moment the executive loses majority, they have to resign. So this is the control that the legislature has on executive. Further, through tools like question hour, the members can ask questions to the ministers. Then the budget is voted. No money from Consolidated Fund of India can be spent without Parliament passing it, except the expenditure which is charged, like salaries of judges, etc., to ensure their independence. But anyway, so no money can be spent without the permission of the Parliament. Thus, this way, the control over executive is kept. Now, with respect to the judiciary and executive, now the judges are appointed by the executive. So the collegium of judges in Supreme Court, they recommend what judge to appoint, and then the judge is appointed by the executive, that is by the president. And then there's obviously the power judicial review on executive action if it is following the right procedure, if it is consistent with the constitution. If it is not, judiciary can declare such an action null and void. So thus judiciary has control over the executive. Similarly, legislature and judiciary, removal of judges can be done by the legislature. The process is difficult to ensure the independence of judges, but still the process is there. So if the judge is not functioning or is misbehaving, then the judge can be removed by the legislature. And similarly, legislature's action can be reviewed by the judiciary. And recently, even a constitutional amendment act which created National Judicial Appointment Commission was declared unconstitutional by the judiciary. So such is the power of judiciary over legislature as well. So thus we see how this system of checks and balances together with the separation of power works in the Indian system. Now finally, we will discuss two cases related to separation of power in India. So the first one is Ram Joaya case. You need not know the case name. Just remember this one line that Supreme Court said. It said that separation of power in India is not of absolute rigidity. Rather, the Constitution has sufficiently demarcated the functions of the organs of state. So basically it is saying that the Constitution has given detailed provisions to demarcate the function of each of the organ of state. However, separation of power in itself in India is not followed with absolute rigidity. That means it's not watertight for sure. Now using this interpretation, some experts have rightly said that separation of power in India can be talked about as separation of functions. So, because sometimes even the executive can legislate, so the legislature can delegate power of legislation to the executive. This is called as subordinate legislation often. Like executive can make rules and regulations, whereas legislature makes the laws. So this is with respect to the separation of power. You can say it is not absolutely rigid in India, rather the constitution has give sufficiently demarcated the function of the organs of state. In the Keshwan and the Bharti case, Supreme Court said that separation of power is the basic structure of the constitution. Now we'll discuss this case in detail, then you'll understand what is the importance of basic structure, but just know that it is basic structure. Why is that? What happened? What led to Supreme Court saying this is Parliament basically removed the power of judicial review with respect to constitutional amendments, that is under Article 368. For this reason, the court opined that judicial review is needed, it cannot be taken away because it ensures separation of power, which is a basic structure of the constitution. So thus, what you can say, what you can derive from these two cases and even use it as conclusion in your answer, you can say that though the separation of power in India is not followed with absolute rigidity, however, the constitution has sufficiently demarcated the functions of various organs of the state, and Supreme Court in Keshwananda Bharti case has clearly stated that this separation of power is a basic structure of Indian constitution. So I hope this entire video is clear to you. I'm again reiterating, it is a very important concept of polity. You must understand it because it is essential for all the future developments that will happen through the course. And if you have any doubt, please ask in the comments. Thank you. Have a good day.